Good morning, Gary DeWaal here, and this is Bridging the Week for July 14th to 18th, and today is July 21st, 2014. I hope you all had a pleasant week. No single theme predominated globally this week among the many disparate matters raised by international regulators and through litigation. However, one senior regulator raised concerns about the potential deleterious impact on global liquidity if international regulators do not better coordinate their implementation of the G20 mandates following the 2008 financial crisis, while two self-regulatory organizations' disciplinary actions remind brokerage firms that surveillance of accounts activity is an important part of effective supervision. Let's get started. Last week, Scott Amalia, a commissioner of the Commodity Futures Trading Commission, implored his fellow financial regulators worldwide not to impair markets that are healthy and well-functioning in their rollout of regulations meant to implement the commitment of the G20 leaders in Pittsburgh, Pennsylvania in September 2009 to reform OTC derivative markets. Speaking before a group of lawyers at the Federal Reserve Bank of New York, Mr. Amalia expressed his concern regarding, quote, continuing reports of market fragmentation and fracturing of liquidity between U.S. and non-U.S. markets as a result of diverging regulatory approaches to implementation of the G20 principles, end of quote. Mr. Amalia suggests that the CFTC play its role in promoting competitive markets by re-examining its rules that may have negatively impacted markets, working with international regulators to harmonize swap data reporting, exchange trading, and central counterparty clearing, and making appropriate investments in technology. Regarding central clearing, Mr. Amalia observed that by December 15, 2014, if the European Commission does not find that the U.S. regulatory regime is equivalent to that under European law, U.S. clearinghouses will not qualify for favorable capital treatments by EU banking institutions. The outcome will cause EU banks not to trade through U.S. markets and lead to market fragmentation and the drying up of liquidity, he says. During his presentation, Mr. Amalia also expressed his support for a bill that recently passed the House of Representatives that not only reauthorizes the CFTC, but, quote, also provides important market structure and commission reforms, end of quote. One thing among many that I don't understand, and there are many unfortunately, is that it seems that both EU regulators and that the CFTC are aware of the importance of finding that each other's regulatory schemes related to CCPs are equivalent. However, it is unclear what is the holdup in actually making such a finding. However, this is just one in a host of contentious transatlantic issues that awaits resolution by Timothy Massad, the new CFTC chairman, working with his European counterparts. Hopefully these matters will be resolved soon before, as Mr. Amalia points out, severe damage is done to global liquidity. Good luck to all. The Honorable Colleen McMahon, the judge hearing the 2012 manipulation case brought by the Commodity Futures Trading Commission against Eric Moncada and two other defendants, expressed her belief last week, quote, that the most compelling inference one might draw from relevant trading records is that Mr. Moncada was indeed trying to manipulate the 2009 wheat futures market. However, she ordered a trial of this matter solely to resolve Mr. Moncada's intent. However, in response to the CFTC's motion for a summary disposition, the judge held that respondents had engaged in prohibited fictitious transactions when Mr. Moncada placed offsetting buy and sell orders in two accounts he controlled, where, by his own admission, he intended for the orders to be filled against each other. The CFTC brought his case against Mr. Moncada and the two accounts, claiming he engaged in attempted manipulation of wheat futures on the Chicago Board of Trade as well as fictitious sales on various days in October 2009. The National Futures Association filed an administrative complaint against Forex Capital Markets LLC for doing business with an unregistered entity that was required to register as a commodity pool operator member. From July 2011 to at least August 2013, Forex Capital carried an account in the name of Revelation Forex Fund LP, whose general partner was RFF GP LLC. Initially, Forex Capital declined to open an account for Revelation Fund after determining that RFF was not registered as a CPO. However, Forex Capital opened the account after RFF filed a notice with the NFA claiming it was exempt from registration. The NFA claims Forex Capital should have questioned whether the Revelation Forex Fund qualified for the relevant exemption. Had it done this, claims the NFA, Forex Capital would have seen that the fund did not qualify for the exemption, as it exclusively traded Forex and was marketed to the public as trading only Forex. Forex Capital agreed to pay a fine of $200,000 to resolve this matter. The U.S. Justice Department and other federal and state government entities announced a settlement last week with Citigroup, Inc. related to civil charges arising from the bank's securitization, marketing, and sale of residential mortgage-backed securities prior to January 2009. According to a statement of facts acknowledged by Citigroup, the bank received information that a significant percentage of loans subject to securitization did not conform to representations provided to investors regarding such pools of loans. These misrepresentations misled investors who purchased the relevant mortgage-backed securities and contributed to the 2008 financial crisis, claims the Justice Department. As part of its settlement, Citigroup agreed to pay a total of $7 billion as fines, settlement of claims, and to provide relief to consumers harmed by Citigroup's conduct. Last week, accounting firm Ernst was charged by the U.S. Securities and Exchange Commission with violating auditor independence rules when, prior to 2009, it lobbied congressional staff on behalf of two audit clients. SEC rules require auditors to maintain objectivity and impartiality with clients. The SEC considered E&Y's legislative advisory services for its audit clients as putting the firm into the position of being an advocate contrary to the accounting firm's independence. In connection with this matter, E&Y agreed to pay more than $4 million. And finally, FCM ADM Investor Services agreed to settle a disciplinary action brought by ICE Futures US related to its alleged failure between January 2010 and August 2012 to exercise due diligence in connection with accounts referred by introducing brokers and such accounts' trading activities. In connection with this matter, ADM was charged with a violation of an ICE Futures rule that requires members to supervise the exchange-related activities of employees. ADM agreed to pay $100,000 to resolve this matter. Well, that's it for this week's Bridging the Week. As always, there's more information on each article and more articles on the article version of Bridging the Week on my website. Check it out. Until next week, this is Gary DeWaal, and this has been Bridging the Week. Have a great week. Ciao.